I just finished reading Clarence Page's uh, article on uh, Pam Bondi, entitled in the opinions section, Attorney General Pam Bondi shows loyalty to her audience of one. It got me to thinking about Pam, and I did some research. First of all, I did listen to the entire hearing before the committee on the 12th to get a background on that. I also did some research into her confirmation hearings and read all of the questionnaires and her responses to those questionnaires by the various senators. I want to give her a fair shake. First of all, she is an attorney. As an attorney who was admitted to the bar June 24th, 1991 in Florida, to the best of my knowledge, I can't find anything in public record that shows she's been admitted to any federal court, district court, court of appeals, or United States Supreme Court. However, that doesn't mean that she can't be the Attorney General of either the state of Florida or the United States, simply because she can, in fact, administer other lawyers to do the work in court. She just is not allowed to appear in court if she is not actually admitted to that court, and each federal court has its own admission. If she is, great. If she isn't, another story. As far as Pam Bondi goes, she was the Attorney General for a very long time in Florida. She was an active prosecutor in Florida, and she passed the Florida bar. She was admitted to the state of Florida, and when she was admitted, she gave an oath. And I'm going to give quote a couple of parts of that oath, which I think are relevant. First of all, understand, Florida has one of the most detailed oaths in the country. The oath in part says, I do solemnly swear, by the way, there's only a part of it, I do solemnly swear I will support the Constitution of the United States and the Constitution of the state of Florida. I will maintain the respect due to the courts of justice and judicial officers. To opposing parties and their counsel, I pledge fairness, integrity, and civility, not only in court, but also in all written and oral communications. I will abstain from all offensive personality and advance no fact prejudicial to the honor or reputation of a party or a witness, unless required by justice of the cause which I am charged. A Florida court's oath is considered one of the more detailed, as I said. Those two portions are particularly emphasized in disciplinary cases. Quote, I will abstain from all offensive personality, unquote, and quote, fairness, integrity, or incivility, not only in court, but also in all written and oral communications, unquote. It's frequently cited in disciplinary cases in the state of Florida against attorneys. Part of what goes on in that is when there is conduct that is considered offensive, it's not limited only to courtroom conduct. It's limited to conduct in general. Attorneys are held to a very high standard. Going back to ancient Greece and Rome, the statement was made, the law is an honorable profession. Now, given that Shakespeare in Henry VI did say, kill all lawyers, we'll bypass that. And there have been a lot of other things along the way that have been jokes or otherwise against lawyers. But in the meantime, let's talk about name calling and demeaning others in an open forum. Those absolutely violate the rules of professional conduct of the state of Florida. Now, in federal courts, the federal law is that the federal court's standards of professional conduct are governed by the state in which the attorney is admitted. So if Pam Bondi is admitted to a federal court, she is under the federal rules, or I'm sorry, the state of Florida rules. If she is not, then she's strictly governed by by Florida alone. Name calling, demeaning others in an open forum, absolute violation of that professional conduct in the state of Florida. Even if it happens outside the courtroom, the lawyers are held in Florida to a very high standard, and elsewhere, to a very high standard of civility and professionalism because they are officers of the court. I hate to say it, but on numerous occasions, while in court before a judge or a tribunal, I have had to apologize. I've apologized for statements made both to the other attorney or to the court. It's a common practice that, yes, we get heated. Yes, we get upset. When we're in an argumentative state, things can be said that we wish we could take back. But when they are said, you immediately apologize for it. You don't sit around and think about it. You apologize. Well, in Pam Bondi's case, during the hearing, let's talk about her hearing. She called various senators out and called them names. She was offensive in dealing with whether one of the attorneys knew what he was talking about, even though he was an attorney, even though he'd been another one, even though he'd been in Congress for some time. These are demeaning. It's not limited. Florida law does not limit it to courtroom conduct. Social media rants, public meetings, emails to opposing parties or to others, statements to the press, online forums and comment sections. All of those are subject to disciplinary action. Simply calling an opponent an idiot or a lawyer without any basis is subject to discipline in the state of Florida. Lawyers have First Amendment rights. There is freedom of speech that goes to lawyers. However, it's very narrow, and the lawyer is held to the highest standard. Let's look at what she said about a few things she talked about in her hearing. This is, by the way, her hearing was for the, not in this hearing, but for the her confirmation a year ago. If you are confirmed as an attorney general and the president asks you to fire a Department of Justice employee for political reasons rather than the professional reasons, will you do as he asks? And she said, as I repeatedly stated during my confirmation hearing, I would not have accepted this nomination if I was expected to do so. She talks about the responsibilities of the attorney general, that those responsibilities are independent of any outside influence. And she repeatedly talked about that during her confirmation hearing, that she would uphold the law and not be under the thumb of anybody. It says, one of the questions was, this was on January 15th of 2025. I ask you, what would you do if your career as DOJ prosecutors came to you with a case to prosecute grounded on facts and law, but the White House directs you to drop the case? You responded in the hearing, Senator, I thought that it would that would happen. I would not be sitting here today. That will not happen, will not happen. Every case will be prosecuted based on the facts and the law that is applied in good faith, period. She then, in her written statement, responded that yes, that is the case. Will you commit to protecting America's public health and environment from corporate polluters by preserving the agency's regulatory authority in our nation's bedrock environmental laws, including the National Environment Policy Act, Clean Air Act, and Clean Water Act? Her response was, I fully and faithfully enforce the nation's laws protecting and preserving the environment. Yet here she sits today with no statement as to what action will be taken with respect to the president's basically gutting EPA. She said in her opening statement, the Department of Justice must also return to defending the foundation of rights of Americans, including free speech, free exercise of religion, and the right to bear arms. The senator asked in writing, I am curious that you selected two of the fundamental freedoms, but not the others in your opening statement. Her response was, my remarks were not meant to diminish the importance of the freedom of press, the right to peaceably assemble, and the right to petition for redress. She said the Department of Justice was established to enforce the law and protect the constitutional rights of all Americans, including all of the rights set forth in the First Amendment. After the abuses of the Watergate era, Griffin Bell spoke directly to lawyers about the importance of an independent Justice Department. He said it's improper for any member of Congress, any members of the White House staff, or anyone else to attempt to influence anyone in the Justice Department with respect to a particular litigation decision, except by legal argument or the provision of relevant facts. Her response to that was yes, she agrees that that is the case. She says, do you agree that the enforcement of decisions should be fully insulated from pressure from the president? If so, what will you do if and when the president applies pressure to initiate particular investigations, prosecutions, civil or criminal? Her response was, the president is the chief law enforcement officer of the United States, and all prosecutions must comply with the Constitution and all relevant statutes. As I stated repeatedly, I would not have accepted this nomination to serve as Attorney General if I believed President Trump would ask me to do this. I think it's pretty clear that at least when she wanted the job in January of last year, she held forth that she would not be at all influenced by the White House. So with Clarence Page's opinion article, giving her the benefit of the doubt, let's assume she has not been influenced and she hasn't played only to Donald Trump. If she has, I challenge her to hold up all of those statements she made during her confirmation hearings, that she would not in any way, shape, or form be influenced in any way by anything anyone in office asked her to do, or even suggested that she do, or that she direct any of her people to do. If so, she's in violation of her oath as an attorney for the state of Florida. In resorting to name calling, in resorting to arguing with officers of Congress, she is also in violation of the rules of professional conduct of the state of Florida. At the very least, she owes an apology, not only to the committee members, but to the general public for her statements and any action she has taken that violate her oath as an attorney. If she does not, she should be disciplined accordingly. And as I say, that's all I have to say about that. And a good day.